I know there has been a piece done by Fieldsports Britain about the appeal Mr Upton brought against the restraining order placed on him in May to protect myself. I have been in communication with Charlie Jacoby, and whilst he asked me to comment on it, he refused to let me comment about the court case. I could only comment about dog training, which seemed strange seeing as the piece is concerning the court case. So while Mr Upton and his lawyer and Jacoby get to say their piece about the court case, Charlie Jacoby refused to allow me to say my piece. Now, I've never wanted to go to the press, and I won't go to the press. But what I will say, I do need to make some points clear, because there are some facts placed in the piece by Charlie Jacoby that are incorrect, totally incorrect. So, this had nothing to do with the methods of Mr Upton towards his dogs. The methods of dog training was not on trial. The RSPCA did not vindicate Mr Upton's methods, and in fact they told Mr Upton that what he was doing to the dogs was mentally and physically harming them, and they continued to say at this point of time they would not prosecute Mr Upton, but if he continued they would do so as they had enough evidence. After that, Mr Upton stopped showing his physical punishment, cutting the clips. He only talked about it. The RSPCA cannot charge someone for talking about it. Mr Upton had already been given an order by the police in 2015 after he called me at 5 o'clock in the morning, calling me a spastic because I suffer with epilepsy. In this call, he says how he is coming to get me. By this time, Mr Upton had called me on numerous occasions, threatening me, and even his daughter called me pretending to be from the disability team. Whereupon Mr Upton placed on public media my address, phone numbers, and how lucky I am my head wasn't found on a pole in my sunny garden, and how 300 years ago they knew how to treat people like you. Epileptic people were considered to be witches 300 years ago, and therefore they were often beheaded and burnt. What had I done to Mr Upton to deserve this attention? Politely disagreed with Mr Upton's training methods on my own Facebook page. I have never created a petition or reported Mr Upton to any official departments other than the RSPCA. Over Storm, they didn't even take my name, for 50 other people had already reported him. And the police I've reported him to the police, obviously, over the hundreds of phone calls and threatening vulgar YouTube clips he makes about me or to me. In these videos, Mr Upton tells me how I am his, talks about us being in a relationship, and how he has sodomised me. As you can imagine, to hear somebody say that he's in a relationship with me when they are like that just terrifies the life out of me and sickens me greatly. He talks about how he's going to wear a gimp mask to turn me on, and then he gives me a safe word to use for when it gets too much for me to take. He sings love songs to me. Every time the police went to charge Mr Upton, an inspector from that area had it stopped or lessened. The laws need to catch up to protect women from people like Mr Upton and his family. Even when the restraining order was in place, Mr Upton was found just outside of the restraining order, parked up in a lay-by. Of course, they couldn't do anything about it because he was just outside the restraining order. It is normal practice in England to give an acquittal for a restraining order, freeing busy courts up as no trial has to take place for this, and saving money, while protecting the victim. This is what happened in May. Sadly, what the CPS and the judge did not realise when doing this is that cannot be done when both parties are not in the same jurisdiction, i.e. I live in Scotland and the other person lives in England. Mr Upton's lawyer did, however, notice this. And Mr Upton made a video directly after court talking about the technicality the lawyer had noticed, but went on to say how they would not use it unless they had to, for he wanted to see me in the witness stand. Obviously, Mr Upton decided to use it, not surprising when all the evidence is on my side and none on his. So that was what the court was about on Friday. The CPS could offer nothing to the courts to say the restraining order should stay in place, for it was clear because of the jurisdiction it couldn't. It was literally a technicality. At no time has there been any actual trial. At no time has Mr Upton been vindicated. He has not been found guilty or not guilty because no trial has taken place. What he has been told by the RSPCA is that his methods of training cause great harm mentally and physically towards the dog. And he has had orders placed on him to protect me, though sadly because of the technicality they had to be dropped.